Good morning. Kevin Rooney on behalf of the appellant, Mr. Todd Mumma. I'd like to reserve 3 minutes for rebuttal, please. The indictment in this case was inadequate. It did not provide the required notice regarding the offense. It was not sufficient to apprise Mr. Mumma of what he must meet, to use the language of the court's cases. It was essentially a form. You violated this statute.
It was a what?
Essentially a form.
But haven't we said, like in the Woodruff case, that you generally can follow the language of the statute? And that was what was done here. There were general date ranges given and a general location for purposes of venue. I mean, there isn't like confusing or overlapping dates like in the Hilly case. So
Correct.
Why isn't this sufficient under Woodruff?
Because of two different things. One, the broad time range of the alleged offense or offenses, because that's one of the problems. Was there one visual depiction? Were there numerous? It's not set out. So one, it's a 3-year time frame in a county, and the statute. And
But do they have to list? I mean, we see a lot of these cases, and sometimes they have hundreds of exhibits. Do they need to list all of the hundreds of them in the indictment?
No, certainly not.
Well,
but they
so
need.
they can generally describe the offense in a date range, and that's sufficient notice, isn't it?
What the defense position is that the offense wasn't sufficiently described. The elements were set out. A very broad date range was set out. A location is somewhere in a 6,000 square mile county was set out, and that was it. And and this is what I wanted to be delicate about.
But it says he knowingly employ and use a minor to engage in any sexually explicit conduct.
Correct.
So, I mean, how are you not on notice? Any conduct, I mean, you ask your client, did you engage? I mean, is there any conduct that could fall within this?
And I think that's precisely the problem, is that, and first of all, I want to be really clear. The test is whether this indictment is adequate on its face. Is certainly a bill of particulars doesn't solve it. Counsel's discovery efforts doesn't solve it. Counsel's discussions with the clients doesn't solve it. What we're talking about is this notice that at some point during a 3-year period, you did something that you employed or used a minor to engage in some sexually explicit conduct.
Well, but it picks out, the statute covers a lot of different things, and it
Right.
picks out employs, uses. It makes clear that this is a production offense.
I don't know that that's clear, because it said there, it also says was produced or transmitted. And that's another one of the problems. The statute is relatively complex. There's several different elements to it. And none of those, there was no facts asserted, no facts pled with regard to any of the elements. I agree, all the elements are set forth.
But here's the problem I'm having, going back to Woodruff. Woodruff says, with respect to an indictment, it quotes a case about information, but Woodruff is an indictment case. In the Ninth Circuit, the use of a bare-bones information, that is, one employing the statutory language alone, is quite common and entirely permissible so long as the statute sets forth fully, directly, and clearly all essential elements of the crime to be punished. Why isn't this sufficient under that standard?
So what the error that the district court found in Woodruff was that the impact on interstate commerce, that the indictment did not allege or specify the theory of how interstate commerce was impacted. And that was a tangential part. Woodruff was a interference with interstate commerce by robbery. And it's back in 1995, 3 jewelry stores are robbed. $618,000 back in 1995 worth of jewelry is taken. And the impact, marginal, a tangential part of the offense, the impact on interstate commerce. Here, and what I put in the reply brief, was the heart of the offense is what exactly was done. What's the sexually explicit conduct? What are the visual depictions? Were they produced? Were they transmitted? What instrument was used?
It clearly says produced, because I'm looking at the indictment, and it says, did knowingly employ and use a minor to engage in any sexually explicit conduct for the purpose of producing any visual depiction of such conduct. And the visual depiction was produced or transmitted using materials that had been mailed, shipped. So, the interstate commerce element is either produced or transmitted, but we know that there's production.
Correct. I agree with that.
Can I ask you a question about the forfeiture issue?
Yes.
Do you agree that this dollar amount forfeiture here is a substitute forfeiture?
I don't know that I agree that it's a forfeiture. It was a money judgment.
Right, but the money judgment is on a substitute theory. The property to be forfeited was the house was sold, the money is substitute for the house,
Agreed.
And therefore, okay. So why isn't there no jury trial in that case under 32.2E? Because E is a specific provision about substitute property, and it says there is no right to a jury trial under Rule 32.2E. So why wouldn't that be dispositive of that issue? I don't think anyone cited this, but we read the rules, and it's right there in black and white. It says if the government shows the property is subject to forfeiture under 32.2E1, and then it explains the procedure, and E1 is substitute property that qualifies for forfeiture under an applicable statute. So the rule seems to declare that there's no right to a jury trial if it's a substitute forfeiture, and yours is a substitute forfeiture.
You've put me on the spot a little bit by raising
Well, maybe you can,
this.
before you come up for rebuttal, maybe you can think about
Where I think the distinction was the government clearly alleged in their forfeiture allegation they also included substitute assets, and everyone agreed that had the defendant asked for a jury trial, he would have been entitled to a jury trial. That was the position of the district court. I see my time has expired with the reservation of time.
We'll give you time for rebuttal.
Okay.
Yep.
Thank you, Your Honor.
Thank you.
May it please the Court, Mackenzie Hightower on behalf of the United States. Your Honors, Woodruff, as you pointed out, is exactly on point in this case. The indictment was sufficient. It alleged what, where, when, and how the offense played out here.
Oh, it doesn't even identify the victim, doesn't even identify the location of the property. I mean, I understand that they can be bare bones, but this is about as bare bones as they come, isn't it?
Your Honor, I direct your attention to the Moreland case in the Ninth Circuit, where they said that the specific victim of issue does not need to be specified, because only, if you look to the Hamling case, only facts that are so specific as to guilt need to be specified. And minor has a legal definition, and so does sexually explicit conduct. So for those reasons, they don't need to be any more specific.
But so when you get, I mean, I guess, are you taking a little bit of a risk when you put in this kind of a bare bones indictment? Because presumably there could have been victims you weren't aware of. But if he got convicted on the ones you were aware of during this time period, and then there were victims you weren't aware of, would he be able to claim double jeopardy in a subsequent proceeding? Because he'd say, well, you didn't identify the victims, but, I had 5 victims, and, I am therefore presumed to have been charged with all 5 of those, even though only, 1 or 2 of them came up at trial. Are you putting yourself at a risk? Does he have a broader double jeopardy claim in the future based on a bare bones indictment like this?
Yes, Your Honor. He would have a very broad double jeopardy claim in the future, but I think it's also important to remember that in Russell v. United States, that's a Supreme Court case, they said that any future-looking double jeopardy claims, you consider the entire record. So in this specific case, the defendant had over 4 years to know the exact victim in this case.
I see. So he still, if there were 5 victims and only 2 were in this case, and 3 weren't mentioned at all, he would not actually have a double jeopardy claim.
According to the case law at issue here. And Your Honor's brought up notice as well. And if you look to the record, the defense actually explicitly rejected a bill of particulars in their filings. And if someone is so concerned with notice and ensuring that they know or adequately appraised of the crimes against them, he could have sought a bill of particulars, and in his filings, he specifically stated that he was not seeking a bill of particulars. Turning now to the forfeiture issue, if there's no other questions to that, I just wanted to briefly correct some of the records. The Phillips case is directly on point here that states you can receive no jury determination on a money judgment. And
what about his counsel before he sat down was suggesting that everyone had agreed that he would get a jury trial if this was under the forfeiture. He thought that everybody had agreed there would be a jury trial.
But it'd still been the House. He would have gotten a jury trial, correct?
Yes, under 32.2, if it had been the House itself unsold.
Well, the whole thing comes down to the fact that this was a substitute property forfeiture.
Exactly.
And yet neither you nor the defense counsel cited the correct rule, because it appears to me that this case is entirely governed by subdivision E of 32.2, which nobody cited, which deals with substitute property and says there's no jury right. Am I wrong in that?
No, Your Honor, you're directly on point, and the government did allege in the forfeiture allegation any substitute property would be forfeitable. So for those reasons, we do believe that the issue would be foreclosed by 32.2E, as you pointed out. And if there's no further questions on any of the issues.
I do have a question about the forfeiture mootness because everyone agreed, and the government agreed up front, that there was a miscalculation of the amount. $2,500 got double counted, and the government had said that it should go back for that correction. But then you filed a 28J letter where you said, oh, actually, it's now moot because it's all been paid out. And in his response, he said, well, actually, the government didn't say that. It's paid out because the government garnished it. And so the government was actually the one who took the amount. And you can remedy that by ordering them to undo what they did. What's the correct answer here? Are they right that it was due to a government garnishment of more than the amount that was warranted?
No, just to correct the record a little bit on that, Your Honor. So after a lawful final order of restitution was imposed by the district court, the government did place an order of garnishment for $10,000, and then the defense themselves approached the government and said, we want to get restitution behind us. You can look to the record at page 46, and they said, instead of paying $10,000 a month, we want to actually pay $20,000 a month. And so they proposed doubling the amount that they wish to pay. And they were also, again, on notice. In our notice of garnishment, we reminded them that they had not requested a stay, which would have been their natural remedy if they believed there was an error in the restitution. And since they did not request a stay.
When did the error come up? Did they know the error at the time, or did that only come up on appeal?
That came up on appeal in their initial brief, Your Honor.
So how was the final payment made? Was it voluntarily made by the defendant, sent in the next round, and that was the last one, or was there any sort of a garnishment? Once we filed the order of garnishment and the defense came forward and we settled on a double amount, the restitution payments were expedited greatly. And so through the joint settlement, they paid the last payment.
on
All
in
those
October.
payments were just voluntarily sent in, including the overpayment.
Yes, Your Honor, according to the joint settlement. If there's no further questions, I'll give back the remainder of my time and ask the court to affirm the district court's findings.
We'll hear rebuttal.
Can you address this issue about the overpayment?
Yes. So there's, of course, Mr. Mumma has separate counsel on the civil matter that's pending. There's a civil lawsuit pending by the victim against him. The government filed the garnishment, and the civil counsel approached them. There was apparently $670,000 that was owed or was garnished that was impacted. And
Hold on. The 670 wasn't garnished, though. There was I don't understand. Was there an order for 600? There wasn't.
No, there was $670,000 in total, and the garnishment was for whatever the amount was for a lesser amount.
$10,000.
Yeah, and I apologize. I'm not familiar with the exact amount. Civil counsel did exactly what counsel said. He arranged for a $20,000 a month payment. The payment of the lawful funds, there was a lawful debt that was being paid at $10,000 a month to Mr. Mumma. He expedited it, paid the $20,000. That's the situation. After that payment was made, then the government agreed to release the garnishment. We can call that voluntary. We can characterize that however we want.
But the bottom line is the money wasn't obtained through a garnishment. It was obtained through a settlement.
I would say the garnishment certainly expedited the settlement.
I understand that, but they didn't get the money through a garnishment. Garnishment is what you go and you get a court order that the money is paid out. That didn't happen here.
As I understood it, and as I understood garnishment, perhaps I don't, is the money was frozen pending a final disposition, or for whatever reason the third party that had that money didn't pay it directly to the government. He suspended payments to Mr. Mumma while the matter was resolved. And in any event, what the argument is that there's a pending civil lawsuit. There will be a remedy for Mr. Mumma if this court says, one, clearly $2,500 is an arithmetical error that's been conceded, and two, this $30,000 is...
So you're not necessarily asking us to order that $2,500 be repaid. You say that if we correct the form of the order to say that the amount was wrong, that'll have the collateral consequence in the civil context of making clear that he's overpaid and get an offset.
Correct. Correct. That's
and therefore, it's not moot because that's some relief.
Correct. Okay. Partial relief. And then there's also a separate issue of there's $30,000, and I think a fair reading of the record is that's some mixture of a down payment on the home and the temporary living expenses, and only the temporary living expenses are properly ordered with regard to restitution. I'd like to turn...
What about that issue, though? Because, I mean, I agree it was a little bit ambiguous there, but what are we supposed to do with that? I mean, did you ask for a...
I asked for a remand to the district court.
No, but at the time, I mean, was there an objection?
Yes.
Okay.
In district court, that was raised in district court. It was, I believe it was oral.
Then there must be more than what I just read.
There's in the excerpt of record, there's definitely a comment by defense counsel about the down payment. I flagged that in the brief, and it is in the excerpt of record. And if I could turn to, again, the adequacy of the indictment. You know, one of the questions you asked is the breadth of the double jeopardy is uncertain. And I think that really illustrates the adequacy of this indictment.
Well, but it sounds like it's not really that uncertain. I mean, the government might be taking a greater risk that it's broader, but if I understand it correctly, you look at the whole record, and so you'd be able to go through and parse this out, not just based on the indictment, but all the evidence.
What I'm saying is the indictment should put Mr. Mumma on notice. It's very clear, I agree, that it's a fine call because it's very clear in the law that he is not entitled to an exhaustive or detailed recitation of the facts, the evidence, et cetera. But our position, he's entitled to more than a bare bones thing that's saying sometime in the past 3 years, you violated this statute by actions you took in Fresno County. And that's just not consistent. It's very hard for him to establish a variance between the indictment and whatever trial evidence the government puts in because the indictment is so vague. It's frankly a fact-free indictment. Rule 7C1 talks about facts.
So
as
why
is
didn't you
necessary.
ask for specificity? A
That
bill of
was
particulars?
the
I'm sure there's some strategic reasons behind that.
Right.
But admittedly, you could have.
Certainly, there certainly could have asked for a bill of particulars, but what counsel did in the district court, and very correctly, I think, laid a great record, was saying this indictment is inadequate on its face. It gives this man as little notice as possible. It's like we might as well just have a form that says, here's the law, you violated it, and your violation happened at some point in the past 3 years, and how you did it, figure it out. And that's not what the Sixth Amendment, that's not what Rule 7C requires.
Okay.
Okay. Thank you.
Thank you. Thank you to both counsel for your arguments in the case. The case is now submitted.